I need to say that I'm really pleased to be able to chair this panel today on asylum in Europe and the Common European Asylum System. Researching this area is extremely topical, as we all know, but notably even more this week, as the European Parliament and the Council have finally agreed to establish the European Union Agency of Asylum, which will replace and upgrade the European Asylum Support Office, EASO. So even more topical to be talking about that this week. The new agency, the European Union Agency of Asylum, intends to make processing of asylum applications more efficient. Yet, much will depend on what is considered to be efficient in times when we see increasing pushbacks of asylum seekers in EU countries with high number of demands. Today, we'll hear from our distinguished panelists about a variety of aspects concerning the theme of asylum in Europe. We will start with a presentation reflecting on the judicial heterogeneity in the 27 EU member states and how that impacts on the construction of a truly common European asylum system. We'll then delve into the analysis of the Nordic asylum appeal models and their interactions with politicization, legal culture, and international law. Finally, we'll hear from the ASYFAIR team with a presentation of their findings, pointing out to the inconsistencies in asylum adjudication in Europe and the consequences that this has on the operational level. And with that in mind, without further ado, I'll give the floor to Cristina Dallara, who is an associate professor at the University of Bologna in Italy, Alice Lacay, probably saying it wrongly, even though I asked before, also from the University of Bologna in Italy, and Madalina Moraru, who is a senior research fellow at the Masaryk University in Brno in the Czech Republic, for their presentation on heterogeneous judicial models for the asylum claims at national level, which consequences for the common European asylum system. I'll give the floor to you.
Good morning, everyone, and thank you very much, Anna, for the introduction. Of course, it's a pleasure and an honor to be presenting in this panel, and also alongside my colleagues Alice and Cristina. So I'll briefly start with introducing you what is the research question that we have and why did we choose this one. So our main research question is what is the impact of the heterogeneous judicial models of hearings in asylum proceedings on the common European asylum system? Alice, can you go forward? Thank you. And a few words on why we decided to choose the right to be heard and hearings in asylum proceedings. Because as we probably all know, the Common European Asylum System establishes and confers various important rights in asylum procedures. But we consider the right to be heard to be probably the most important in asylum proceedings, because without this right, there's no effective protection of the principle of non-refoulement. As we know, there are actually very few written evidence in asylum proceedings, and the decision on whether an asylum applicant is entitled to receive refugee protection or subsidiary protection relies very much on his oral statements. And so we would consider hearings as the most important element in asylum proceedings. Another factor of why we chose the right to be heard and hearings is the fact that it's quite an insightful text case for deciding what is the impact of the various models of domestic asylum hearings on the effective implementation of EU law. And what we found is that if we look at the asylum proceedings, and in particular the EU secondary legislation on these hearings, and the most important instrument is the recast asylum proceeding directive, we see that there are various provisions that confer expressly right to oral hearing, both in administrative phase of asylum proceedings and in the judicial phase of asylum. But there's also quite an extensive level of national discretion left to the member states on deciding how to organize the hearing. At the same time, the European Court of Justice, and Alice, can you go forward with the next slide? And at the EU level, what we see that there's quite a prolific, thank you, the next slide with. There's quite a prolific involvement of the European Court of Justice, which in dialogue with national court have actually filled the gaps that we have in EU secondary legislation. So I've mentioned that the key instruments in EU secondary legislation are Article 1418 in the recast Asylum Proceedings Directive, which confer a right to an oral hearing by administrative authorities. And on top of that, during the judicial phase of reviewing the administrative decisions, there's a clear right to an appeal before a national court conferred in Article 46. And we could say that these are quite exhaustive provisions that are conferred by EU secondary provisions, which we don't find in other, for instance, public administrative proceedings at the national level. But the European Court of Justice has actually found additional rights to be heard. And Alice, it would be great if you go to the next slide. So mapping out what actually has been the contribution of the European Court of Justice is that we see additional right to be heard in accelerated administrative proceedings. Also, the European Court of Justice establishing what is the remedy in case of violating the right to be heard by the administrative proceedings, rights that are actually not expressly provided or are provided differently at the national level. Nevertheless, next slide, Alice, thank you. Nevertheless, although we have this extensive contribution of the European Court of Justice in how the right to be heard should look like and should be implemented, there's quite an extensive extent of the national discretion left at the national level. And this is precisely the research question that we're trying to look at. And that is, how have national court applied the discretion that has been left by both EU secondary asylum legislation and the European Court of Justice? And we tried to look at this in two ways, both bottom up and top down, and concentrating on 5 key countries and on 6 factors. So I'll give now the floor to my colleague Alice, which will go in depth into the comparative assessment of the 6 countries and 6 factors. Thank you very much.
Thank you, Madalena. I go ahead with slides. So in this preliminary stage of the research, we tried to, as Madalena said, we tried to focus on possible structural and procedural factors which can have an impact on the effective guarantee of the right to be heard in different EU member states. In order to do this, we will focus in this pilot test on 5 countries: Italy, Greece, France, Germany, and Romania. Since they have interesting characteristics in terms of the implementation of the asylum system, in particular, can offer interesting insights on the right to be heard. They adopted different models, and in particular, we will focus on 6 factors in order to see how these 6 factors are combined in these 5 national models. The factors we decided to analyze are first of all, the remedy for violation of the right to be heard. So we would like to focus more on what happened within courts. So if there is a possibility to conduct a new hearing by courts in order to guarantee the remedy for violation of the right to be heard, and and if courts can decide on the merit of the claim by recognizing a form of protection, then we would like to focus on the suspensive effect, since in cases in which the suspensive effect is not automatic, this can lead to possibly this can lead to the return of the asylum seeker, and so the violation of the right to be heard. And also in this case, there are different procedures and practices adopted by member states, as well as in the case of legal aid, which clearly have an impact also for what concerns the suspensive effect and the possibility to challenge the decision at first instance on appeal. We think also that it could be relevant to focus more on what kind of model is adopted in the different national EU member states, if they adopted a decentralized or centralized model, since we hypothesize that in cases of decentralized models that probably there could be also differences within the same country on procedures adopted for what concerns the hearing or for what concerns the suspensive effect, for example. And also we think that it's important to go in depth on accelerated procedures, because in some countries in case of accelerated procedures, the interviews or the hearings in courts are differently conducted, and this can lead to consequences on the right to be heard. And finally, we would like to focus on the appointment of judges, since the power of the courts probably are different in relation to their appointments. So briefly, we don't have time to go in depth on the 5 countries we analyzed, but this is only some preliminary insight on these countries, and we would like to also listen for your comments and to improve that during the discussion. But for example, in the case of Italy, we think it's extremely interesting to state that differently from other EU countries, Italy delegate the appeal to civil courts instead of administrative courts, and these clearly have differences in terms of the examination of the case, since, for example, differently from Romania or other countries, the Italian judges cannot annul the decision made at first instance, but they can only re-examine the case for scratch and evaluate if there is the right to stay for the asylum seeker to stay in Italy or the risk of no refoulement. Another important element could be the suspensive effect. So the fact that in cases of appeal in the higher court, the Court of Cassation, the judge, the suspensive effect is not automatic, and in that case, the decision on the suspensive effect relies on the same judge who made the rejection on the civil court. So this can lead to some problems on the effective remedy on behalf of the Court of Cassation. Another last element on the Italian case is that according to our preliminary findings is that the decentralized model seems to lead to some divergences in terms of the decisions on suspensive effects among courts, as well as some relevant differences in how courts conduct hearings, as well as interviews of the asylum seekers. Indeed, it seems that in some courts, judges decide to conduct only the hearing, which consists on the encounter with the lawyer, asking for clarification to the lawyer without asking clarifications to the asylum seeker on their personal statements, while in other courts they decide to conduct this interview in all cases. So there are very different practices. For what concerns the Greek case, one important element is that courts conduct only written hearings, and only in few cases they conduct oral hearings. Another aspect is that for what concerns procedural interviews, procedural accelerated procedures, the interviews are conducted in different ways in relation to the regular procedure, we can say. For example, in admissibility procedures, in the case of Syrian asylum seekers, the interview can also be conducted by police officers, differently from interviews in regular procedure, and this can lead to some disparities also because of the lack of specializations of these professionals. The last element of the Greek case, I think which is interesting, is concern the legal aid, since it seems from reports and literature that the legal aid is guaranteed at the national level. However, there are important obstacles which can lead to some difficulties for asylum seekers to obtain legal aid, which is necessary to challenge the decision of first instance. For what concerns the French case, we can say that one relevant aspect is differently from all the other countries we analyze. It is a centralized model, and we would like to understand if this can have different impacts in the way in which the hearing is conducted at national level, if this can lead to less divergences, maybe more uniformity among judges in the way to conduct hearings, and also in the case of suspensive effects. And the last aspect on France is that, differently from other EU countries, the panel is also composed by a specialized member appointed by the UNHCR, and this can have interesting insight, probably also if we compare other countries as Germany or Romania, in which the courts are not specialized at all, and they deal with each area of law. And finally, for the German case, we think one of the relevant element is that the accelerated procedures, asylum seekers have only 7 days to appeal. So also the time is extremely relevant, and this can lead to some limits in the remedy of violation of the right to be heard. And also on this aspect, we would like to go in depth on our research. It seems that divergences among courts emerge also at for what concerns the legal aid. Courts in Germany differently evaluate the merit test, which is necessary to obtain the free legal aid in the German courts. Yes, finally, for what concerns Romania, we think that the most important thing is that they cannot decide on the merit of the case, completely different from the Italian one, since they can only annul the decision made at first instance, and the merit is only delegated to the administrative authority, and also that, as in the Greek case, for what concerns accelerated procedures, it seems that in admissibility procedures, they only do a preliminary interview without going depth on the merit of the claim. So this can have some problems also if we consider that then the courts are the courts are not specialized. So we would like to go in depth on this also in this on this aspect. Yes, maybe Christina, you can.
Yes, I apologize because it seems to me we don't have additional time. Just 2 words to conclude. The idea is that me and Alice are working since 2 years on the Italian case, and we know Maddalena since some years at the time at UI. And the idea was try to verify if the conclusion we hypothesize from the Italian case, that is that the point of the decentralization of asylum courts around the country, and the point that in Italy the appointment was limited to civil judges already working in the Italian courts without other type of professional analyzing the asylum request. It seems to us they are the 2 main factors that could explain why in Italy, in the 26 courts specialized on asylum, we had a huge heterogeneity on how the right to be heard is implemented. Italy is, in my opinion, limited as a sort of crucial case, but the idea with this research that we could start is to verify if in other countries there are institutional factors related to the governance of the judicial systems that could explain why in the national system hearing and the right to be heard is implemented in that way. We have the chance, and I'm concluding, to having the door of courts open, because in Italy we are doing this research working within the courts, within the tribunals. I'm working on the judicial system since many years, hence I'm also a professor of the National School of the Magistracies, and in that way we have the connection to work directly with judges. The same way, we would like to use the European network of judges and the European network of the magistracy schools and the training institutes, try to enter in the courts in other countries, starting from the 5 countries that we have listed in this research proposal. Our aim was, with this presentation, to establish connection with other researchers and with other scholars that have in mind something similar. And it seems to me that already yesterday, something a similar idea was presented. So for us, it's really an important occasion to share our expertise and our idea. Thank you so much.
Thank you all 3 of you for this very insightful presentation. And indeed, I'm sure there will be many points of convergence with the research of others in this room and in the conference as such. So we'll now hear from William Hamilton Byrne, who is a postdoctoral research at iCourts at the University of Copenhagen in Denmark, and Sarah Scott Ford, who is also at iCourts as a PhD candidate, also at the University of Copenhagen in Denmark. They will present on the constitution of the normativity of protection in Nordic asylum appeal systems. So I see that we have the slides on, so the floor is yours.
Thank you, Anna, for the introduction, and thank you, ASYFAIR, for having us today. It's a huge honor to present to you today. I, William, will present with Sarah our paper on the co-constitution of normativity of protection in the Nordic asylum appeal system. Our research in this paper stems from a broader research project based at iCourts called Data for All, where we apply data-driven techniques to study the Nordic asylum systems. Today, I'll present to you the general introduction and theoretical background, and then Sarah will present the second half, going into some of the more nitty-gritty with data. This paper is still very much in its early stages, and in particular, we have not started some of the more comparative work. So we appreciate any and all feedback that you may have, particularly on the methodology as we go forward. So I will commence. Our paper is a sociological exploration into the social practices that shape the normativity of international refugee law in the Nordic countries, Denmark, Sweden, and Norway. In this paper, we posit that the organization of asylum appeals represents political and regulatory choices about how to deal with legal decisions that are plagued by radical uncertainty. We suggest that the regulatory compromise that we see merges particular conceptions of asylum expertise, in particular legal, political, and factual, as a kind of co-constituted normativity. As hopefully over the course of the presentation will come clear, our paper is in many respects an intervention and a call for greater socio-legal attention in the discourse on refugee status determination and asylum appeals. What we call for is a shift from legal analysis focusing on legal sources and empirical analysis undertaken on a micro level, focusing on deep ethnography, and a macro level focusing on international institutions to zoom in on a meso level of practice legally and politically. Our method is to analyze the appellate systems in the Nordic countries in their historical iterations on the basis of public documents and examine trends in large chaos file analysis of legal materials. And towards the end of the presentation, we will give you a brief insight into what we are finding with the manifestly ill-founded cases. At a later stage of the research, we also anticipate that this will be accompanied by interviews with practitioners. So we take as our object the Nordic countries, firstly, due to our proximity, of course, but also because of their particular and some respects unique experience with international human rights and refugee law. The Nordic countries were amongst the earliest signatories of the international human rights and refugee law regimes. But in recent years, this commitment has given way to a more minimalist approach to international norms with restrictive asylum policies. Despite their commonalities, the structures for asylum appeals in this region are remarkably different. And in our paper, rather than taking a holistic perspective, we suggest that each country has significantly been shaped by issues of national legal culture and the politics of legal knowledge within these systems. In this context, we submit that the institutional architecture of refugee law appellate systems and the types of knowledge that make their practice concrete might tell us something about how international refugee law is made at a national level in daily activities. So in respect of theory, we begin from the premise that refugee law is plagued by radical uncertainty. This argument is seen across a range of disciplines, for instance, law, social science, and Foucauldian studies of governmentality. But refugee law appeals also take place in context of wider changes to law and society. In our paper, we draw on the sociology of risk as formulated by Beck and Giddens, which looks at the role of science in modernity and suggests that due to changes in the nature of time, space, and technology, uncertainty is now a fundamental condition of the human being. In the risk society, risk analysis is taken to absorb and manage risks. Science constitutes risk as risk worth addressing, but also becomes relative in the face of greater uncertainty. International legal theorists have approached the sociology of risk mostly through a focus of the role of experts in global governments, where law is mostly seen in instrumentalist terms as enabling power and politics. We project that contemporary migration fits well with this notion of the risk society. As Catherine Dauvergnat has argued, asylum law is responsive to perceptions of a loss of control over policy initiatives and state sovereignty. Some scholars have looked at the role of experts in defining migration and thereby justifying a securitization discourse. Other scholars have sought to quantify asylum systems as governed by chance, a refugee law roulette or asylum lottery, ultimately suggesting that it's a procedure of facticity. But in issues of risk, law enables as well as constrains. More specifically, in our paper, we project that law and risk exist in a dialectical relationship as what counts is as uncertainty is shaped by the laws that are already in place and how these laws are interpreted in a specific legal cultural framework. We submit that this contextuality calls for greater socio-legal attention towards the social and cultural processes in which law is made. More specifically, what we want to focus on is the role of norms, whether they are legal, cultural, or social, in making refugee law. Our paper thus moves from more ethnographical approaches with their rich attention to legal social detail and more institutional approaches that recognize the role of structures in constituting social norms to embrace practice theory, which focuses on the productive tension between structure and agency, zooming in on the minute details which make up the big picture of international law. In particular, we take inspiration from Thomas Gammeltoft Hansen and his research on practice of legality, whereby competing scholarly, institutional, and policy practices create perceptions of conformity with international law to the extent that international law becomes a representation of both law and politics. Following this, we follow a more pragmatic turn in practice theory, and in particular, Antti Wiener's theory of contestation, to focus on contestation as a social practice that is expressed through routine behaviors and discourse that shapes the values that matter to people. Practice theory shows how asylum decision makers decide in a context that is international and national, instinctively, automatically, and recursively. Shifting the lens from quantifiable risk to the co-production of uncertainty allows us to engage reflexively with the axiological context in which international refugee law is constructed. So what we're aiming for is a particular kind of research where we can focus on the particular kinds of expertise and epistemologies that are formed in asylum appeals, in particular, historical iterations of legal, political, and scientific or factual expertise that merge and form a particular kind of co-constituted normativity. So I'll now hand over to Sarah, who will show you more concretely how practice unfolds in the Nordic asylum system.
So what is the general way that asylum appeals are set up in the Nordics, and what can we derive from this kind of comparative exploration? Well, let me get to this by first describing each system and the general model that they can be characterized as. So in recent history, the most dramatic change to the asylum appeals in the Nordics was in Sweden with the 2006 court reform, where the specialized appeals board that had been previously was changed to 3 and later 4 decentralized migration units within the administrative courts in Sweden, plus a higher court of appeal and a unit within that. This makeover was supposed to make the system more legitimate. Previously, there had been both low granting rates and the involvement in the ministry, both acting as the final instance and also appointing members to the board, which did not really sit well with Swedish ideals of the rule of law, with this mixing of the political and judicial branch. So this full makeover was aimed at resolving this tension and the resulting uncertainty by aligning it with the court system instead. In Denmark, there has been the same institution, the Refugee Appeals Board, since the appeal was introduced in the Aliens Act in 1983. However, it's gotten several makeovers throughout the years that have been highly charged, politically speaking. So it began with 7 members, but already it was cut to 5 members in 1995. It's a judge as chairperson, as well as members appointed by different ministries, the civil society organization Danish Refugee Council, and a lawyer association. So on this image, it would be the individuals facing us. Across from them sits the claimant, the lawyer, the translator, as well as the representative from the first instance, but they do not usually participate actively in the hearing. It's an inquisitorial model, and the overwhelming majority are these types of oral hearings. In 2002, however, it was scaled down to 3 persons after political concern that members appointed by the interest organization Danish Refugee Council would not necessarily be independent. They couldn't settle on 4 persons because it needs to be an uneven number. So the one member that had been appointed by the foreign ministry was in a way collateral damage in the reduction to 3 ultimately. And these particular members that were appointed by the foreign members were also ones that often came with specialist knowledge gained through international work, for instance, often in diplomatic functions. Then due to a subsequent political decision in 2013, it was again changed to 5 members. But it lasted not only about 4 years, because then it was cut down again to the 3, and that's where it is now. So now we have a judge, a member appointed by the Ministry of Immigration, and a lawyer member appointed by the Lawyers Association. So this began as this vision of the expert model, but it became politically questioned in the context of a restrictionist bent to Danish politics since 2002. This was understood to jeopardize the legal legitimacy that the model ultimately aspires to, being independent. However, by that logic, the argument could be extended to one of the remaining 3 members who was appointed by the parent Ministry of Immigration. And the stakes to formal impartiality are even higher, since the route to judicial review in ordinary courts are cut off due to the understanding that this type of appeals board provides a specialized, thick form of judicial review, in each case using their special knowledge. And on this basis, the Supreme Court has limited the ordinary court's power to review these cases. In Norway, there's the Aliens Appeals Board, which was set up with the creation of a proper appeal system in 2001. It handles other immigrations other than asylum, and they may create special grant hearings with more board member if there are sort of cases of a general or principal nature. Most cases are decided, however, by the secretariat or a single judge, but sometimes it might lead to an oral hearing before a 3-person board, which you see on the image, where the other 2 members, apart from the judge, are appointed either by the Norwegian Association of Lawyers, the Association of Social Scientists, the county governors, and by voluntary organizations, including the biggest refugee interest organization in Norway. And there might also be country guidance experts sitting in on the hearing. And through such appointments, it bakes in an element of social legitimacy, however, only in a quite smaller subset of cases. Unlike in Denmark, a negative decision may be appealed to the ordinary courts by the board or the applicant, and could exceptionally go all the way to the Supreme Court. And if the courts find flaws in the initial decision, or not the initial decision, but the appeal board decision, they'll send it back to the board for a final judgment. So comparing how these appeal systems have been constructed historically, we can say that boards can be fitted to the special needs of the asylum system or the political will more easily than courts. They may also rely on different forms of expertise. On the other hand, courts may be implicitly understood to be more independent and insulated from political process, and therefore confer legitimacy to the handling of asylum, generally speaking. However, also when you look more closely, these different models are not stable and usually compromises that reveal certain tensions that relate to how uncertainty is dealt with at an institutional level. We'll eventually compare data sets of different types of decisions of all 3 appeal systems, but at the moment we've only gotten to the Danish data, where we currently have access to a database of 30,000 appeal decisions, which is not a lot compared to the countries we just heard about, but in Denmark, this is a substantial amount, almost all in the time period. And we would like to take you to a quick tour to manifestly unfounded cases, because these are usually exempted from the usual judicial review. So therefore, it's interesting to trace what happens to these cases once they do actually proceed to appeal. And also in the Danish case, they have quite an interesting trajectory. So manifestly unfounded cases are usually ones that are siphoned out of the ordinary process because they are deemed to not be needing the deeper review that asylum seekers are generally afforded in the Nordic countries. These cases are usually exceptions in different ways and might also involve hasting the cases through, bringing up what Jill and Hambly have recently called legal quickening. In Denmark, these are divided into 2 categories, so-called content empty, which are seen to be not about refugee status determination, and prospect empty, which goes further than manifestly unfounded cases usually do, because it's based on what the national authorities deem to not fall under national or other protection status, basically what the board has sort of stated as its practice. It also includes cases where the caseworker believes that the claimant provides statements about their identity or facts that are deemed clearly untrue or not credible. However, there is a fail-safe of sorts built in. The specialist organization, Danish Refugee Council, the very same that I mentioned earlier, that had the previous role of appointing members, gets a chance to veto. So all are sent to an interview with them, and if the Danish Refugee Council agrees, usually the majority would end there. However, if the Danish Refugee Council does not agree that it should be characterized as a manifestly unfounded case, then it will lead to rejection by the first instance and an automatic appeal at the board level. And here it's usually subject to a limited review, usually by one judge, usually written. But if the judge or secretariat decides, it might proceed to an oral hearing. So through this intervention, the system thereby vests a kind of legal power in the Danish Refugee Council. And in cases we looked at, they come in and say, wait, this part was not considered. There's a diagnosis here perhaps, or they actually have a fear based on sexual assault that they have not disclosed, these types of things. And the Danish Refugee Council will often buff up the arguments by referencing to country guidance reports or to decisions by the European Court of Human Rights, for instance, and kind of bring that into the case. So we suggest that this should be understood as one form of risk management, risk to the integrity of the hearing, the integrity of the hasting through of certain decisions and circumventing ordinary rule of law safeguards. So you bring in this form of social legitimacy through an interest organization. And what we see here is that the management of risks is thus mediated through this procedural failsafe, which is considered trustworthy because it's upheld by a long-standing refugee interest organization. And it also leads to the DRC becoming much more involved in the actual practices of the board overall, because they of course need to have an in-depth knowledge of what goes on at the board, what the board's practice is, in order to be able to make the cut whether the case is actually manifestly unfounded or not. And so since the 1990s, they've had this database of all the board's decisions to be able to sort of be kept up to date. And this is quite remarkable when you might remember how the system and collaboration exists in the middle of political backlash to the very same institution appointing members to the board. So we see how across these diverse and specific practices, political choices enter and structure the system. Later on, we'll be able to say much more about what it means for the way these cases are decided. But if one thinks that the veto power would lead to a substantial amount of manifestly unfounded cases being overturned, that's indeed not the case. What we know is that they've used the veto power in about 350, 400 cases since 2000. And of these cases, only 27 are finally granted. So it's like 7% success rate at best, and which is far below the general rate of overturning cases. So this suggests that the label manifestly unfounded does stick, even though it gets disputed, which might come down to a larger point about the effects of being perceived either as an economic migrant or as not credible. And it might also come down to the single judge written procedure. And of course, we should not also overlook the ability of the first instance to correctly sort of siphon off actual sort of unfounded claims, right? At the same time, in a broader institutional sense, the revision of the first instance power to find cases manifestly unfounded itself is important, we suggest. It might have its own effects. For instance, I mean, one thing is just the fact that the court, the DRC became more involved, right? There might also be other ways that this sort of plays out and has an effect. But we still need to do further research here. And in the future, we want to look into more different ways such NGOs interventions work in the Nordic appeals system, among other things. We look very much forward to your questions and any suggestions that you might have for our ongoing study. Thank you.
Thank you very much for this fascinating presentation, and I'm sure we'll have the opportunity to discuss in more detail with the members of the audience here. And I'm really enjoying all of your presentations and the fact that everybody is keeping to the time, which is fantastic. So now we will move to the last presentation of our panel today, and we'll hear from Nicole, who is a postdoctoral research fellow at the University of Exeter and a member of the ASYFAIR team. She'll present on the topic of exploring inconsistencies in refugee status determination in Europe, operational perspectives on asylum appeal adjudication in practice. Nicole, the floor is yours.
Thank you very much. I hope you can hear me. Is everything okay? Yeah, you can hear me? Perfect. So in this presentation, this presentation is based on a paper we have submitted to a journal recently and is currently under review. So thank you for listening to our presentation on behalf of my co-authors as well. So this presentation is adding to Nick's keynote presentation yesterday, and we are exploring the inconsistencies in asylum adjudication in Europe, and we draw on our ethnographic observation to show factors that may undermine the fair treatment of asylum applicants across the EU. Oh, doesn't work? No, it does. As you already know from Nick's introduction at the opening session and his keynote yesterday, ASYFAIR focuses on one specific aspect of an asylum seeker's administrative journey in Europe, which is the appeal at the court against the first instance or ministerial decision of their asylum claim. ASYFAIR looks at both international and local deviations of procedural standards that may impact negatively on the right to be heard. So that is, rather than focusing on the success rate of appeals or the legal doctrines and law that underpin asylum adjudication, we look at what is actually happening at the European courts in the hearings. To use Cameron's analogy, so rather than focusing on the rules of the road, ASYFAIR looks at how the car is driven. Local deviations, as the co-panelists have already addressed, are a problem because it can lead to what American researchers have referred to as refugee roulette and introduces an increased risk of refoulement, as well as a chance of arbitrariness into a process that should be predictable and secure. And this leads to broader questions of what happens to Europe's ability to protect refugees under international law. Very quickly about our research methods. So we have conducted legal ethnographies, observing public asylum court hearings of adult asylum applicants in the UK, Germany, France, Austria, and Belgium. In conjunction with this, we have collected statistical survey data on key elements such as timings, numbers of questions, etc. And my colleagues have also conducted interviews with legal professionals, asylum seekers, and other participants in Italy, Greece, and the UK. And most of our publications are open access, and you can find a list of these publications on our website. Now, there are many differences between EU member states, as my co-panelists have already addressed, and Nick has also addressed in his keynote yesterday, and here I just add a few more of our findings. So countries varied in terms of the publicness of the hearings. So some countries like France, the UK, Germany, and Austria have public hearings that anyone, including us researchers, can attend, while other countries such as Denmark and Italy do have in-person hearings, but they are not, as far as we know, publicly accessible. Greece has no oral hearings as a rule, and lots of hearings in Greece are on paper only, without anyone, including the applicant, present. In France, in principle, all hearings are public, but as our researcher Jessica experienced, many hearings, especially those concerning women and vulnerable asylum seekers, are often closed sessions, meaning they are not permitting an audience. In Germany, on the other hand, where I have conducted my research, we can almost speak of too much publicness or hyper-publicness, which was an inflexible insistence on public hearings in which applicants rarely have the chance or indeed the legal right to ask for a closed session. As I observed in Germany, this can result in difficult atmospheres during hearings, especially when applicants are asked about sensitive issues such as sexual and domestic violence or sexual orientation, which I will present later today in panel 5A. So just to give you an ethnographic example, I was present in a hearing in Berlin where about 15 university students piled into a very, very small hearing room, and the appellant questioned their presence presence, and he looked very uncomfortable about it. But the judge frowned, he looked very annoyed and said in a raised voice, quote, "This is the public and they want to watch your case. In Germany, our system is open for public scrutiny," unquote. Publicness is an important consideration at court hearings because on the one hand, public scrutiny may, and I emphasize may, moderate judicial behavior. Also, appellants are able to go and observe other hearings in advance of their own, which can help to put them at ease in Paris that happen routinely, as my colleague observed. If courts do not allow public access, it may impact on the appellant's ability to bring supporters with them to the hearing. And again in my observations, I have seen that the role of supporters present in hearings should not be underestimated. However, too much publicness is also problematic for appellants, especially for those who would prefer to be heard in confidence when they disclose sensitive information. Legal systems also differ on whether they are adversarial, as in the UK, or investigative, as in Germany. However, systems can change internally depending on other circumstances. So, for example, with the absence of government representatives in German courts, the German judge has to fulfill more and more adversarial roles in their investigative hearing, meaning they are taking over the role as the opposition, which may impact on the appellant's perception of the role of the judge. The judge normally is the mediator between the appellant and the German ministry. But in the absence of the ministerial representatives, the judge had to take over this role, which they found very difficult to explain to appellants who perceive the judge as, quote, just another branch of the ministry, unquote, rather than an independent judicial body who make their own decisions. And just to give you an idea, in my observations, only 11% of the cases I have seen in Germany had a government representative present. More interestingly, in France, my colleague Jessica only observed a single hearing out of 160 hearings with OFPRA, which is the French government ministry, present. In the UK, on the other hand, Home Office representatives were almost always present. Another example of this procedural culture, quote unquote, are the recording of transcripts of the hearing. So in Austria, all court hearings have a court writer who types what is said throughout the hearing. And at the end of the hearing, the transcript is printed out and translated for the appellant once more before the appellant signs it as a confirmation that the recorded statements are accurate. In Germany, almost all hearings we observed were recorded on a dictaphone by the judge. That does not mean that the judge puts the dictaphone on the table and records everything. Rather, the judge is picking up the dictaphone and records what has been said. So many judges would stop frequently in order to speak into the dictaphone with information that somebody has already heard to make this official record. The negative side of it is that this may lead to stilted conversations that are disjointed and difficult to follow. On the other hand, countries such as France, Italy, and the UK are not formally recorded. Appellants who would mount a second appeal to challenge the legality of the process during the first appeal can expect more difficulties if there's no record. And also judges have no official record to refer back to when writing their judgments. And many German judges told us that they go back to the transcript of the hearing before they are making their judgment, just to see, just to read it again and get a better information. So producing a transcript may therefore be again both positive and negative. A transcript of a hearing can be used to mount further appeals, can assure quality, whilst it may have a negative effect during the hearing when the act of transcription, both via a court writer or a dictaphone, can interrupt the flow of the conversation and the narrative of the appellant. Now, another issue is the technology and video links in the courtrooms, which is increasingly embraced in the UK and France through so-called remote hearings via video links. In Austria, courts partially welcome video links to hear expert witnesses and interpreters who are abroad. In Germany, on the other hand, all judges I've spoken with rejected video links because they insisted that this would, quote, be against the notion of publicness and the right to a personal oral hearing, unquote. At the time of our research, and we are not sure that this is accurate, maybe the Italian team in my panel can verify that. So in Italy, legislation has been approved where judges could base parts of their decision on video recordings of the initial government interview. Most interviewees in Italy objected to this new legislation and said that that the video recordings of initial interviews was a poor substitute for an in-person appeal because applicants are normally not legally represented in the initial interview, may have been unable to disclose important information, and they also questioned the questioning style of government authorities because it's not the same as the quote-unquote objective questioning style of the judges. During the COVID pandemic, UK courts used online hearings during lockdowns, but have since turned back to face-to-face in-person hearings, as far as we know, because there were concerns of risk of off-screen coercion, finding an appropriate space to conduct a hearing from, inequalities in technology access, possible distractions and difficulties in communicating with interpreters, and legal representation during the hearings. So again, video links raise certain questions. So firstly, would video links really save resources? A judge in Austria told us that they question this argument because they said it still requires vast amounts of financial and technical investment in facilities, not only in courts, but also in detention centers, for example. But it also requires the same staff. You still need somebody to check the entry and endpoint, you need a technician, you need an interpreter. So maybe it's not as resource saving as people think. Also, the question arises, just a second, whether video links is really the same as sitting opposite of somebody else in an oral hearing. Can the same emotions and sincerity be transmitted? Our colleague Jessica reported that video link hearings in France had a strange atmosphere, in her words, quote, filled with disembodied voices, unquote. In Germany, judges mentioned that credibility is the most important aspect of appeal hearings. So we have to question, is there a possibility that technology can reduce credibility? And that leads to another analytical question, whether credibility is linked to performance. And unfortunately, I can't get into this. Now, to add to this, let's look at the differences within EU member states. And here I focus exclusively on Germany, because this is where my research is taking place. So Germany has 52 administrative courts in which asylum cases can be heard. And we conducted our research at 6 of these 52 courts in 4 different federal states. And we have observed more than 280 hearings there. And you have to keep in mind that in Germany, asylum hearings, as was already pointed out by the previous speakers, are integrated in administrative law. So we have observed the differences, for example, in timing. We saw that there were quicker hearings at different courts. In Düsseldorf, for instance, some hearings are only scheduled for 15 minutes, with one judge being able to hear up to 8 hearings per day. In Berlin, on the other hand, hearings are normally scheduled for around 2 hours, with judges normally hearing 2 to 3 cases a day only. In part, this is explainable because cases from certain countries are more common at certain courts due to the dispersal that I can't discuss right now. Also, a country of origin is a factor. So Nigerian cases, which are considered a so-called safe country of origin, are normally faster in comparison to, for example, Afghan cases, which tend to be significantly longer. Also, some types of cases, like religious conversion cases, tend to be more complex and longer. So just to give you an example, the longest hearing that I have observed throughout my fieldwork was almost 7 hours long and concerned religious conversion. There are nevertheless regional differences, as you can see here in our average hearing times graph. So this is also explainable because in Berlin, most judges assess each case individually from scratch, whereas in Düsseldorf and in Munich, judges only ask, quote, follow-up questions, taking their cue from the initial government decision rather than fully revising the facts of the case. And this is also visible in these hearing times. Another issue that concerned us are legal deserts. That is, do appellants have equal access to legal advice and legal representation in different locations within a nation state? So we heard from our interviews that lawyers, especially those more experienced and better established, are sometimes reluctant to travel to more remote locations. So as you can see in the graph in Germany, 88% of appellants in Berlin had a legal representative, whereas in Augsburg, which is a more rural area with sometimes difficult public transport access, only 34% of appellants were legally represented at the hearing. And this raises very fundamental and important questions of the equal and fair access to effective legal remedy. Now, a few concluding remarks. Our ethnography has highlighted how the practical implementation of asylum appeals differs across the European countries we have studied. However, we do not suggest that such inconsistencies justify intervention to, quote, equalize the setting and practices of refugee law. Differences may simply reflect alternative ways of doing things, and in Germany, for example, they are often based on historical circumstances. As Costello and Hancock write, many diverse procedural forms are intrinsically fair, so there would seem to be little justification for general harmonization in the name of fairness. So different legal traditions combined with the different workload pressures that asylum determination places on different areas of European member states also make a one-size-fits-all approach unrealistic. For CEAS, the question remains whether total harmonization is both possible and desirable. To standardize the few points I have outlined in my presentation today and the ones that Nick covered in his keynote would represent an uncharted degree of standardization of EU member states' justice systems. And such national traditions of justice, adjudication, and legal practices are often seen as fundamental in maintaining national sovereignty, and invasive reforms may be impossible. And living in the UK with Brexit, we can see the negative effects of too much standardization, or at least the perception of too much standardization within the EU. Nevertheless, to explore and outline inconsistencies in asylum adjudication procedures raises fundamental issues of fairness for asylum seekers and applicants. Although we do not propose a unified asylum adjudication system in Europe, our research raises these important questions for the international obligation to protect vulnerable migrants. Thank you very much, and I look forward to your comments and questions.
Thank you, Nicole, for this fascinating presentation, and thank you for all our panelists for these three very insightful, fascinating, brilliant presentations. I really enjoyed hearing your findings. Thank you all very much for your great presentations. I honestly really enjoyed hearing all these different aspects of your presentations from different countries and different views and methodologies, and with some convergences, especially concerning the role of deference and of discretion in this field. I really appreciate having the opportunity of chairing this fantastic panel. I think we're going to end on the dot here. Thank you so much. If we were in person, I would be applauding. So thank you so much all for your great presentations, and the audience for the comments.